Yes, Mr. Mwite.
My Lord, on the first issue regarding the scrutiny of Forms 34As and Bs, I wish to support the sentiments of Honorable Orengo that perhaps this court needs to give instruction to directions to its registrar to increase the staff that are undertaking that exercise. Because from what I understand from my client, the number of staff is too low to be able to accomplish that exercise in good time. So we are also anxious that that exercise should be completed in good time before 5 p.m. And the way to do it is for the registrar of this court to increase staff to such numbers as we enable the exercise to be completed in good time. On the second one, the issue of access ICT. My Lord, these servers are in Europe.
Sorry?
The servers are in Europe. We are not refusing to give access. Europe is a couple of hours behind us. We had to wait for them to start working. They have to set up the access window with safeguards. That exercise is going on, and I am instructed that that should be completed in the next 1 or 2 hours. So it's not us who are refusing to give access, except with regard to the soft copy that your order has directed we give to them of the logs. We have added a soft copy to the registrar, but my instructions are that our opponents did not accept the soft copy. So as far as the access is concerned, the soft copy, we have complied. The second component of actual access, in accordance with the orders of this court. In fact, my clients are going further because there are some things that are beyond the orders that we are given by the court. But even those that are beyond, bearing in mind the concerns about the integrity, we want to accommodate them by giving them access. And that is what is being worked on by our service providers in Europe, and that should be in place within the next 1 hour or so.
Could I?
You also want to add some, Mr. Ngatia, you want to add something on that?
Yes, my Lord, because the application also affects the third respondent. My Lord, it should be remembered that access is not just to the petitioners, it is equally to the third respondent. My instructions are as follows, my Lord. As regards the team at Milimani Court, they are moving very well. They are about to complete Form 34B. And they anticipate by midday, they'll be towards concluding that exercise. As regards the other team, there is a request being made by the petitioners which is beyond the order that was issued. What that is, my lords, I would request an opportunity for my technical team to respond to this letter in writing, just like to respond to the request which has been made. My lords, if there is a request which is beyond, that is really overreaching, both parties should be bound by what was to be made available to them. So, my lords, I do not think it's at this time there is any alarm. The registrar, as Learned Counsel Mr. Mwite has said, is in full charge of the process. And we anticipate by early afternoon that results would start being made available. That is all.
So there is no obstacle to complying with the court order?
No, none. None.
There's no obstacle with complying with the court order.
My written instructions and also through my telephone, there's no obstacle.
Yes.
And it's being done plainly in the presence of everybody. But there was a request for a facility beyond the order that was made, and that was turned down. If that is what is being called an obstacle, is to use the word obstacle wrongly. That was a request beyond the order, and that will be put in writing in the terms that I'll be able to present to the court.
Tell your clients to observe the court order.
No, we are just receiving. We have nothing to do. We are receiving.
Tell the clients to observe the court order.
Yeah, it is actually
my clients, not his client.
Yes.
And my lord, it's an issue of logistics. We want to comply with these court orders to the letter. And there is no difficulty about that. It's an issue only of logistics, not obstructing, not wanting to comply. And you are going to explain that from our technical team to show the challenges that are there. But the orders will be complied with. Yes.
Okay. Then, Mr.
I don't want the impression created that we are obstructing or not wanting to comply with the court orders.
Yes. Then, Mr. Orengo, why are you interrupting our proceedings? No. I'm saying what they are saying, the court order is being followed to the letter. Why are you here?
No, my lord, that is not true. In regard to what my lord friend, Mr. Paul Mwita said, he's saying there's no non-compliance because the people in Europe are still asleep. My lord, you remember these orders were made when they were well awake yesterday. So the excuse of saying that the people in Europe are still asleep, I think is not justifiable. By the time these orders were made yesterday, and Europe is about 2-3 hours behind us, they were fully awake. Now we are being told this morning that we have to wait until they wake up. And my lord, you would expect this matter to be concluded by 5 p.m. So what we are just urging is that there should be full compliance. We are not going beyond the orders of the court. We are very conscious of what those orders of the court were, and we are quite happy with the orders the court had made. So we need compliance in time so that when we come here at 5 o'clock, and remember, my lord, we are only going to be given 10 minutes. So we need also to prepare our responses so that we don't take a lot of time from the courts. So that's all that I wish to say.
Very well. We gave the order yesterday morning. It is for the parties and their agents to work out and comply with the order within the time specified by the court. At 5 o'clock, we want a report. Anybody who will not have complied with the court order will tell us why he has not complied, and we will determine whether or not failure to comply was reasonable.